Now come to the backbench motion on whistleblowing. Sir Norman Lamb to move.
Thank you very much indeed, Mr Deputy Speaker. I beg to move that this House calls for a fundamental review of whistleblowing legislation to provide proper protection for a broader range of people. And I'd like to thank the Honourable Member for Stirling for the support in making the application to the Backbench Business Committee, together with all the other MPs who supported the application, and to the Backbench Business Committee, indeed, whose chair sits before me, for enabling this debate to take place, because I think it is on an incredibly important issue. And I want to start by telling 4 brief stories to illustrate why facilitating whistleblowing is just so important. Now, Mr Deputy Speaker, I was the Minister in the then Department of Health that initiated the review led by Bishop James Jones, of the former Bishop of Liverpool, into the horror of what happened at the Gosport War Memorial Hospital. And if you read his report from June last year, the very first chapter deals with nurses who in 1991 tried to speak up about their concerns about what was happening in that hospital. And yet the report refers to the silencing of nurses' concerns. It refers to a patronising attitude towards those nurses who tried to do the right thing. And the consequence of not listening to those nurses is the extraordinary and horrifying conclusion of that report that over 450 older people died as a result of the inappropriate prescribing of opioids. Old people who'd gone in for rehabilitation but came out having died because of inappropriate prescribing. And this, Mr Deputy Speaker, highlights the fact that we can be talking often about life and death situations. So enabling and empowering people to speak up literally can save lives. That, at its most clear and stark, is why this is so important. This horrific scandal at Gosport Hospital could have been stopped if those nurses had been listened to, and they weren't. And that in itself is an outrage. Scroll forward now to 2013. Dr. Chris Day, a brave junior doctor working in a hospital in South London, raised safety concerns about nighttime staffing levels in an intensive care unit. Now, it's in all of our interests that if there are concerns about the safety of any part of our health service, but perhaps particularly an intensive care unit, that brave people speak out. But what happened to him, because he spoke out, was unacceptable, wholly unacceptable. He suffered a very significant detriment. His whole career has been pushed off track. His young family have been massively affected by this. The junior doctor in that unit was put into an invidious position, being responsible for far too many people compared to national standards. So he pursued a claim against both the Trust and Health Education England. £700,000 of public money was spent by the NHS in defending against that claim, in large part attempting to deny junior doctors whistleblowing protection against Health Education England. Lawyers, disgustingly, were enriched. Late last year, the tribunal that eventually heard his case ended early after Dr. Day was threatened with a claim for substantial costs. He and his wife couldn't face the prospect of losing their home for their young family, and so he caved in. It is surely a scandalous treatment of a junior doctor. He was defeated by superior firepower. We have the grotesque spectacle of the NHS, of all organisations, deploying expensive QCs to defeat a junior doctor who raised serious and legitimate patient safety issues.
Will you give way?
I will.
Thank the honourable member for giving way, and I pay tribute to the work he's done on the Dr Chris Day case to really get the answers that I think we deserve about the way he has been treated. But I just want to ask him a little bit about the inequality of arms that many people, whistleblowers, face in tribunals. They've often lost their jobs by the time that they're at that point, and they really are, as you say, facing very difficult situations where highly paid QCs are really running rings around them, and actually it's often as a result of employers trying to find loopholes in the law to avoid liability.
Well, I thank my honourable friend for that intervention, and I thank him for his support in pursuing the Dr Day case, and I completely agree with the points that he has made. Sir Robert Francis, in his report Freedom to Speak Up in 2015, evidenced whistleblowers who'd given evidence to him, whistleblowers in the NHS, overwhelmingly experiencing negative outcomes. He talks of a hostile culture of fear and blame, isolation, reprisals and victimisation in our NHS, for goodness sake. And the stories continue. The impact on the individual can be devastating and profound. Being ostracised, abused and disadvantaged in your career. Dire consequences for your mental health. One nurse who tried to expose wrongdoing said, and I quote, "I would never put myself in that position again. I would rather leave." What a damning indictment on how we treat people in our treasured and cherished public service. I will give way.
I'm extremely grateful to the right honourable gentleman for giving way. He and I both worked a bit on the general issue of whistleblowing, and I pay tribute to his leadership on this matter, along with my honourable friend for Stirling, who I hope will catch your eye later, Mr Speaker. There are just 2 points I want to intervene on, the very good points that he is making. And they are these. We know 2 things, don't we? First of all, that across the country there is very strong concern about the way whistleblowers are being treated. We see it in the West Midlands, and he is articulating this point. But secondly, we know also that whistleblowers help ensure, through the role they play, that we have proper accountability and transparency. And in my view, the work that he has done and the work that others are doing on whistleblowing has not received anything like the amplification it requires.
I totally agree with the points that my right honourable friend makes, and he makes them very well. And I will come on to the point that he made in a moment. I'm just conscious, very quickly, but I'm conscious I'm nervous about the Deputy Speaker.
Just reassure, I hope I don't make anybody nervous, Dr. Goodlake.
Thank you, Mr Deputy Speaker, and thank the honourable gentleman for giving way. He's most generous with his time. It was really a genuine question, which is, with the gentleman the doctor feeling under pressure from the overwhelming firepower and the cost potential to incur the NHS's quite substantial costs, can I ask what support this, the gentleman's unions, such as the BMA, or defence unions like the MDU and MPS, might have offered him in terms of legal costs?
Well, in that case, rather shockingly, the BMA abandoned him, and that's a story in itself, which needs exploring further. But it's very often the case, not just in the NHS, but across the economy, where people are literally on their own, faced by very expensive lawyers. I speak as a former employment lawyer. I know what happens in employment tribunals. These were intended as a layman's court. They're anything but that these days, I'm afraid. The third story I want to mention is of my constituent Mark Wright, a successful financial planner at RBS. But things started to go wrong after he raised concerns about unacceptable practices in the bank before the crash that was. And then on the 17th of September 2008, immediately after the collapse of Lehman Brothers, an intranet statement was put up in RBS referring to the fact that the group was well capitalised. Now, this was clearly an attempt to reassure staff, and including staff shareholders and customers and investors, that the bank was secure. Of course, what happened when the bank crashed, those staff shareholders lost a fortune, and many believe, including my constituent, that they were very badly misled by that intranet statement. Now, his mental health was destroyed as a result of trying to challenge the bank, and his career was destroyed. He made a complaint to the FCA, the Financial Conduct Authority, who reported his name back to the bank, for goodness sake. They were later criticised by the Complaints Commissioner. I pursued his complaint with the FCA. They denied knowledge of the intranet statement repeatedly to me, yet an internal FCA email emerged dated the 14th of March 2014. That was after a subject access request to the Complaints Commissioner. And that email referenced, and I quote, "The intranet notice that Mr. Wright refers to was online between 17th of September 2008 and January 2009. And I quote, "As staff used it to take reassurance that all was well, which would tend to support Mr. Wright's allegations." That was an email within the FCA. Yet we were never informed of that email or of that finding of that explosive document. It's clear that the FCA has a copy of that intranet statement, yet they will not or cannot disclose it to us. They say that the law doesn't allow them. RBS, which is part state-owned, will not disclose it, yet clearly it is in the public interest that it should be disclosed. I believe I was misled by Andrew Bailey, the Chief Executive of the FCA, who told me in effect that Mark Wright's allegations offered nothing that was not already in the public domain. He referred to an intranet statement by Fred Goodwin, which had been, he said, in the public domain for nearly 10 years. And yet the statement, the intranet statement, has not ever been in the public domain. The Treasury Select Committee, which had looked into this, had never received a copy of it, so I was misled. So we have a regulator that's too close to the banks. We have a regulator that failed to protect his disclosure or his identity. We have a regulator that crucially appeared to fail to take the allegations seriously of the misconduct of that bank, and cannot or will not put a crucial statement into the public domain. Just think, Mr. Deputy Speaker, about the damage caused by bankers in the run-up to that crash. Had we actually empowered people like Mark Wright to do the right thing, rather than destroy them and ignore them, then we might just have prevented the disgusting behaviour and greed of bankers, and we might now have seen some of those responsible for destroying our economy behind bars. As it happens, they have got away with it. The fourth and final story is of foster carers who across the country are frightened to raise concerns about any behaviour from the council that they deal with. And of course the council refers children into their care. So if perhaps a foster carer is concerned about the behaviour of a social worker and raises concerns, that council can just stop the flow of children to them, and so disappears their income stream, their ability to earn a living. And so this has a chilling effect on any foster carer's willingness to speak out about child protection concerns because they fear losing their livelihood. I give way.
I'm very grateful to the Right Honourable Gentleman for giving way, but does that not highlight, whether in finance or NHS or anywhere else, it's in situations where you have a power differential and where you have a hierarchy, that someone actually has power over someone else that can make them lose their job or lose what they love doing, and therefore there's a constant threat?
The Honourable Lady is absolutely right, and that's why we need effective legislation to redress that imbalance of power. So, Mr. Deputy Speaker, all these cases highlight the value and importance of enabling people to expose wrongdoing. Effective protection, let me just make some progress. Effective protection for brave people who decide to speak out is vital, first of all, for that individual. They should be celebrated, not denigrated. But it's also in the benefit of all of us that we give them protection. And this is the point that the Right Honourable Member for Sutton-Coldfield made earlier. It's actually about good governance, this. Keeping organisations honest, protecting businesses from fraud, from crime and from other wrongdoing, maintaining the highest possible standards. Good protection to those who speak out acts as a deterrent to bad behaviour. Closed secret cultures which cover up wrongdoing and destroy those who try to speak up, deliver poor public services or cheat customers in the private sector, including particularly in financial services, or tolerate bullying, sexual harassment and so on. And then so often non-disclosure agreements are the final step that's taken that keeps that wrongdoing secret. It slams the door shut on proper scrutiny, and things need to change. So the question is, does the current law work? And palpably, from the examples that I've given, it is clear that it does not work. It leaves out, first of all, Mr Deputy Speaker, key groups, not only foster carers, who simply aren't covered by the legislation at all. It leaves out job applicants, volunteers, priests. Just think about the abuse of children by so many priests over the last few decades. If priests were given the protection to speak out, then perhaps we would have prevented some of that dreadful abuse. The legislation leaves out non-executive directors, it leaves out trustees, it leaves out relatives and friends of the whistleblower when they're victimised because of what the whistleblower has done. It leaves out someone who's victimised by being presumed to be a whistleblower, the company who thinks someone has spoken out. Even if they haven't and does something like dismisses them, they have no rights under this because they're not actually the whistleblower. That is a ludicrous situation. I give way.
Thank you very much. I'm grateful to the Right Honourable Gentleman. I'm sorry I wasn't here for the start of the debate because I was the co-author of a review of NHS hospitals' complaint system some time ago. And I think he was then at the Department of Health. And one of the reasons we didn't go stronger on that point was because we thought there was legislation in the pipeline, or there was an attempt to put things right for potential whistleblowers. I'm still concerned in my own local authority area from the Cynon-Taf. We've just had the Cwm-Taf Health Authority heavily criticised for maternity deaths. Now, one of the people involved got in touch with me anonymously. I didn't know what to do with the letter. I didn't want to pass it on to the authorities. I passed it on to the Royal College of Obstetricians and Gynaecologists, who were at that time completing a report into the Cwm-Taf Health Authority. It's still a major problem, and people are afraid. Yeah, you know, even when they think, you know, there's greater understanding and leeway, people are afraid. We've got to put that right.
Well, I totally agree with what the Honourable Lady has said. And Sir Robert Francis, who did the report in 2015, recommended the introduction of freedom to speak up champions in the NHS, and that has happened. But this is an administrative process within trusts that simply, I'm afraid, hasn't worked. That's the brutal lesson that we have to learn. So for those who are covered by the legislation, the law does nothing to enable a concerned person to speak up in the first place. The law, for example, is silent on standards expected from employers. It only offers inadequate protection after the event, after the person has been destroyed by a cruel organisation. And the individual then who tries to pursue their rights under this legislation is too often faced by highly paid lawyers and pressured into non-disclosure agreements, which can result, as I indicated, in wrongdoing never being exposed. And indeed, we know that some non-disclosure agreements are indeed in their terms unlawful because they seek to shut up the individual and stop them speaking out, even when it involves a crime. Only a tiny percentage of cases that are pursued to the tribunal actually end up with a decision of the tribunal. In order to succeed, you have to show the reason for a dismissal, or if more than one reason, the principal reason is that the employee made a protected disclosure. So you open yourself up to false claims that other reasons existed. And if the tribunal decides that there were other reasons, your claim is either dismissed or your compensation is reduced. And there's no full definition of the range of disclosures that are covered by the legislation. So the protection is completely uncertain. Disclosure has to be to a prescribed person. But what happens if you don't know who to report the concerns to? You could easily find yourself entirely unprotected for trying to do the right thing. The organisation, I'm conscious that I'm trying the patience of the Deputy Speaker, and I need to get towards the conclusion of my remarks. The organisation, the brilliant organisation Protect, highlights the fact that a number of laws, such as in the utility sector, make it an offence to disclose certain information, and they have no public interest defence exceptions for whistleblowing. So even if there's awful wrongdoing, the person is prevented from speaking out because they would commit a criminal offence. This surely has to change. The brutal truth, Mr. Deputy Speaker, is that brave people who do society a service by exposing wrongdoing are not adequately protected, and many have no protection at all. After Gosport, I met with the Prime Minister. I made the case for reform. I explained to her that these are life or death situations in many cases. Since then, I have heard nothing from the Prime Minister at all, and that was last summer. It is time now for a fundamental review and for new legislation. Such a review by the government needs to listen to all the interested parties, to the all-party group, to Protect, to Compassion in Care, who have set out proposals in what they call Edna's Law. All must be involved, and we must look at international best practice. The all-party group has a report that's due out soon, which follows a comprehensive survey, including getting the views of very many people who have tried to whistleblow, and it will offer vital evidence to the government if they take up this recommendation. They propose an Office of the Whistleblower, which I think could be of extremely powerful value in supporting people, and it would provide a centre of excellence. It would provide guidelines to employers. It would monitor activities. It would provide support, advice and training to members of the public, to public institutions, private sector bodies and so on. It's a very important proposal. I want a commitment from the Minister to undertake a thorough review because it is long overdue. And I want a commitment also to ensure that the UK, if it leaves the EU, meets at least the standards of the proposed new EU directive and preferably goes much further. The UK was a pioneer, but the legislation is flawed and inadequate. Time is long overdue to pass new legislation to deliver high standards of governance in both the public and the private sector, safe space for brave people to do the right thing, and effective mechanisms to hold people to account for wrongdoing uncovered, including potential criminal sanctions, and effective compensation and support for those who suffer as a result of speaking out. Thank you very much indeed.
The question is on the order paper. Kevin Holland-Ray.
Thank you, Mr. Deputy Speaker. And it's a pleasure and absolute honour to speak after the Right Honourable Member for North Norfolk, who has done such incredible work in this area and on the All-Party Group for Fair Business Banking, which is where most of my remarks will focus upon. But many things from his speech resonate with me, but particularly when he said that one of the whistleblowers he referred to said, if I knew now what I know then, I would have spoken out. Every single whistleblower that I have been in contact with has said exactly that. And you know, if that's the case, we have got this drastically wrong. But there's so much good work. The all-party group is doing tremendous work, and many of those people are in the gallery today. But the principle around this, these whistleblowers are so valuable to us in so many ways that he's described. They should be encouraged, they should be valued, their contribution should be valued, and of course, more than anything, they should be protected. And in my experience within the financial services sector, that is the opposite of what happens. And I've got a number of cases I want to allude to. But really, you've got to understand. You'd like to intervene, of course.
It's extremely good of my honourable friend to give way. Just before he moves on to that, can I take him back for 1 second to the last comment made by our right honourable friend from Norfolk North, where he was talking about the importance of an office of the whistleblower, and he was addressing the critical problem of the lack of effective high-level coordinating leadership which exists, which, in my view, the case for a national office for the whistleblower would answer. Does he agree that the creation of a national office for the whistleblower to protect, advise and support whistleblowers by overseeing, coordinating, setting standards and holding to account the regulators and employers is the right way to proceed? It would not, vital point, it would not investigate cases of whistleblowing. It would ensure that cases are properly investigated by existing bodies, and it will also identify failings, successes, and propose systemic improvements which would help get us out of this very difficult situation we're in.
And I do support that principle and many of the recommendations that the right honourable member opposite referred to, and I'll be interested to hear from my honourable friend for Stirling, the all-party group, the chair of the all-party group, to say what their recommendations will be. I just know this is something we've got to get right that we've got wrong today, because the people who take these risks, who step forward, potentially lose everything. It is their career, their jobs, their livelihood, and that's devastating when you go back to tell your loved ones that that's what you're doing. But also your colleagues, your friends at work, all those things, all your self-esteem is put at risk. And in my experience, the ones I deal with, for no benefit. They don't even achieve what they set out to achieve in terms of highlighting the issue, and, of course, suffer devastating consequences as a result.
Will my honourable friend allow me?
Yes, happy to give one.
I'm very grateful to my honourable friend. I'm not put in to speak, as the issue which concerns me is still pending. But would he accept that even being a senior consultant is no protection against what can happen to you if you blow the whistle? I have a case of a senior consultant in an eye unit who became concerned about financial irregularity and, even worse, substandard treatment that was causing eyesight to be lost. And the effect of him complaining was that he was the one who was suspended. He was the one who faced a GMC examination. The Royal College of Ophthalmologists were simply shown the results of an internal inquiry, not the source material. The CQC did nothing, and the GMC is only now beginning to look into his claims, now that they've dismissed the false allegations that were made against him. Isn't that a disgrace?
I couldn't agree more, and he highlights the importance of some of these cases. And you've got to actually say, why wouldn't an organisation want to know about this? That's the point. And my role before coming to this place 4 years ago, as managing director of my own business, and we were quite a large business at that point, I dealt with all the complaints in that organisation because I wanted to know what was going on in the organisation. And it's the best way to find out. These people are your eyes and your ears. And we run an ethical business, we ran it well, but if anything was going off track, we want to know about it. But it seems when these people step forward, the risks of the people around them, their superiors, I guess, feel this situation's too risky, and too often look to close down these complaints. But from the fair business banking perspective, we know that 1/3 of all serious economic crimes are brought to light because of the actions of whistleblowers. This is very rarely the regulator that's going in there and identifying the problems and then dealing with it. In fact, quite the opposite. So it's absolutely fundamental that these people will step forward. And of course, when all the whistleblowers we deal with say, I would never do that again, other people hear that in the sector. And they're deterred then from stepping forward, which is absolutely an intolerable situation. These people should be welcomed. The Right Honourable Member opposite highlighted his case, Mark Wright, and in my experience, this isn't just about the banks themselves, the organisations themselves, it's also about the regulator. The regulator could take a much firmer stance with this. Whistleblowing is part of their process. They've got responsibilities under these protected disclosures to deal with these whistleblowers, but that's not what happens. They pay lip service to this issue of whistleblowing. They say, yes, OK, we're dealing with that, but the cases I will highlight illustrate that that's not what's happened. The FCA has got a terrible reputation in this area. Very happy to give way.
And does he agree that the sense one gets from the FCA is that they regard these people as irritants, troublemakers, and the people who investigate the allegations of whistleblowers are often people who've been through the revolving door in and out of banks and the regulator, and so are too close to the people that they're supposed to be regulating?
I ask myself all the time, why? Why is it like this? And that's one of the reasons, the revolving door, that they are part of this wider group, this wider club, the old boys tie, that kind of stuff. And this cannot be the case. And I say he highlighted a case that was heavily reported on the RBS case, where the FCA then told RBS who the whistleblower was, which seems absolutely unthinkable and was criticised by the Complaints Commissioner. Also, the FCA, when they had the Chief Exec of Barclays, Jeff Staley, when Jeff Staley had tried to find out the identity of a whistleblower, which again is totally against protocol, and then he was fined a modest sum, probably a few weeks' wages for that chief executive. Where's the deterrent there for treating whistleblowers, to not treat whistleblowers in the wrong way? My own experience, we've got Joanne Rousseau, who contacted us contacted the FCA about fraud at Barclays and in terms of PPI claims and under the Consumer Credit Act. But feels have contacted us, feels we've got a total lack of protection and support from the FCA, and the communications around that were simply unacceptable. Paul Carlier, a heavily reported case, he whistleblew on the foreign exchange dealers at Lloyds, was then unfairly dismissed. The FCA promised to support his case, promised to provide an opinion to the tribunal he went to when he was unfairly dismissed, and then did not do that, despite Andrew Brodie at the FCA calling Lloyd's process of treatment of whistleblowers a whitewash and a joke. That wasn't just his case, that was other cases he deals with. And yet these people are not sanctioned. Why is that? Paul Moore, my constituent, was the first person to raise the issues at HBOS in 2004 when he described a toxic culture at HBOS in terms of their lending, the fact they were pressured sales targets, taking unacceptable risks in terms of lending money, and of course in 2008 HBOS collapsed. He was unfairly dismissed. He was treated disgracefully by the FSA as was then. And again, the Right Honourable Member opposite's point, this may have stopped the financial crash happening in the first place. £1.8 trillion that's cost our taxpayers. £1.8 trillion. If we'd taken a robust approach when whistleblowers come forward. Very happy.
I'm grateful to my honourable friend for giving way. Isn't he underlying the point that's been made by others who have spoken in this debate so far, that the regulators themselves are stricken with lethargy when it comes to responding to whistleblowers, and the whistleblowers need the protection of an independent office that will advocate for them with these bodies that themselves are sometimes very forbidding in terms of the approach that the way they respond to the approach of whistleblowers?
Yes, it's absolutely right. And we need to improve how we deal with whistleblowers. We need to improve the legislation around whistleblowers, but also we must insist that our regulators who already have access to sanctions, to dealing with these issues, that they do that robustly. There is a cultural problem in the FCA in dealing with this that we must address, and that can only be dealt with by the leadership of the FCA itself. The most egregious case I've dealt with over a period of 2 years in my time as co-chair of the All-Party Group, has that been a Sally Masterton, Lloyd's HBOS. She was one of the senior risk managers at Lloyd's. In 2013, she wrote a report called the Lord Turnbull Report, which highlighted what had happened at HBOS and the takeover of Lloyd's and the fraud that was being concealed. She wrote this report. It was £1 billion fraud that she identified. These are not just small numbers. These are not small issues. These are the biggest issues, which perhaps is the case that these is the reason why these things are swept under the carpet. But she was asked to set out her findings. She produced this report, gave it to her superiors. She was then suspended. And bearing in mind, this was happening at the same time as a police inquiry into the low-level fraud that was happening at HBOS. She was suspended. She was prevented from working with the police, despite the fact that the police had said in an email she is vital to this investigation. She was suspended. Later, she constructively dismissed. She was then discredited to the FCA by Lloyds. Lloyds wrote to the FCA and discredited her, saying this person was effectively not a cogent witness. This person is a rogue employee. This is not a cogent witness. The FCA accepted that without any investigation, and that was in 2013. 5 years later, Lloyds then apologised to Sally Masterson, said she'd been disgracefully treated for 5 years, admitted that they had tried to discredit her, all the way through that 5-year process. 5 years. You can imagine what the 5 years of her life was like. The FCA told Lloyds to intervene because she felt she'd been terribly mistreated. The FCA, Andrew Bailey himself, had met with Sally Masterson and said and determined she'd been disgracefully mistreated. So they apologised to her. They make a financial settlement with her. But the FCA do not sanction anybody in Lloyds for that mistreatment. I mean, it is absolutely incredible. All they will keep telling me is that there's another investigation going on, a Dame Linda Dobbs investigation of the general Lloyds, the situation around Lloyds, around the reporting of when the HBOS turnover and takeover and afterwards. But there's no way, for them that's unacceptable. They've already established the mistreatment, yet they won't move forward to sanction those people responsible. Under the senior managers regime, these people, just the chief exec, could be sanctioned, fined, banned, and that's exactly what should happen. Happy to give way.
I thank my honourable friend for giving way. He's making a very relevant point, and it's one that applies to my constituent, who's been a whistleblower in the HS2 scheme, where he suffered reputational damage following his whistleblowing of that project. And I'm sure he's about to go on to shortly to talk about how that reputation can be restored and what either the FCA or another body can play in providing protection to whistleblowers, and certainly restoration following their whistleblowing.
Absolutely right. The FCA has a huge opportunity. It should regulate without fear or favour, but that's not where we are. Constantly looks over its shoulder at what the banks the reputation of the banks. It seeks to defend the reputation of the banks by concealing the truth, rather than robustly investigating these issues. I asked Andrew Bailey 4 times a simple question in connection with this issue. Did he follow the processes set out on their website of how they deal with whistleblowers? That her case was supposed to be referred to his team within 5 days and go through the proper process. Did he do that? He has not responded to that question 4 times. It's totally unacceptable. Sally Masterson says in her protected disclosure to Andrew Bailey, this is the 10th time that whistleblowing issues have been raised with you and ignored. That's over a period of 5 years. And despite the fact that the FCA themselves, in communication within the FCA, have admitted her report was well drafted and presented, and also I see a couple of potential risks. This is one FCA person to another. We may get challenged as to what we, the FCA, did about this report when it was received, or our treatment of Ms Masterson.
Again, I'm grateful to my honourable friend for giving way. We should also mention the fact that there was whistleblowing to the FRC in relation to the audits that were done at HBOS, in terms of the amounts of money that were set aside against expected liabilities. The FRC, the head of the FRC, Stephen Hardwell, appeared before the Select Committee that I'm a member of and said some really interesting things about the fact that in respect to inquiries that are ongoing with other regulators in relation to these whistleblowing, but nothing further has been said.
This is around KPMG's audit of HBOS in 2008. a few months before and signed it off before its boss went bust, despite the fact that the risks to that business were clear. And then the FRC gave the KPMG a clean bill of health. And the revolving door between the FRC and KPM and the auditors as well. It's a very big concern, which I know he's raised in select committee work. So, to move on to a conclusion, Mr. Deputy Speaker, there is two... very quickly,
I'm sorry. I'd like to pay... I'm sure everybody would like to join to pay tribute to Julie Bailey. Now, Julie Bailey was one of the best whistleblowers in the NHS, and she triggered the mid-staffs inquiry, the Francis report, and many other issues. She's now living in Wales, and the way that Julie Bailey was treated after she became a very well-known whistleblower is an absolute disgrace, but is an example of what happens to whistleblowers. It doesn't matter how well-known they are.
And she makes a very important tribute and a very important point in terms of how we persuade more people to come forward. And it's got to be how they're protected and looked after. And I think looking at the other international regimes and how they deal with this is an important first step in terms of reforming our whistleblowing procedures. I think the big thing I would say about all these issues I deal with is they do go right to the top of these organisations. These are not low level, these are right to the top, must be dealt with. Also, yes, by whistleblower reform, yes, by a regulator that is far more robust and regulates without fear or favour. I do also believe we need other measures too, including a public inquiry about some of these situations, some of these circumstances around the disgraceful treatment of many businesses, particularly by Lloyds and Royal Bank of Scotland. So, yes, I do endorse many of the recommendations by the Right Honourable Gentleman opposite. I do think, though, we need a much more robust financial conduct authority, regulator. Culturally, the biggest issues in the regulator need fixing. We should look at whether we should provide incentives, financial incentives for whistleblowers of the right kind of nature. But I do think we need to make sure our regulator goes in robustly when we see these mistreatments or these improper practices, together with our law enforcement agencies. That's what happens in the States in these situations. So it's either you deal with us, you deal with these issues, or we really will take further steps, including potential criminal sanctions. The situation is not where we want it to be, but I just would like to conclude, Mr. Deputy Speaker, by thanking the whistleblowers who do come forward. So important. We would not be where we are today in terms of understanding what's happened in the banking sector without the incredible contribution of many of the whistleblowers that I deal with. Thank you.
Fitzpatrick. Mr. Deputy Speaker, I'm grateful for the opportunity to speak briefly in today's debate, and would like to congratulate the Honourable Member for Norfolk North for helping secure it with time generously allocated by the Backbench Business Committee. And I'm very pleased to follow the Honourable Gentleman for Thurston Moulton, who, with so many other colleagues here today, have worked so hard on making sure this issue gets the attention it deserves. I've spoken in this House before about my constituent, Ms Julia Davey, who ran two successful businesses, Angelic Interiors Limited and Angel Group Limited. Despite the multi-million pounds worth of fixed asset and shareholder funds across the two businesses, both ended up being placed into administration, which has lost Ms Davey over £6 million. She followed advice from Lloyds Bank during her time running the two businesses and believes responsibility for the liquidation of her assets lies with them. In 2009, unbeknownst to Ms Davey, her account was transferred by Lloyds to their business support unit. 2 years later, she was told that she must pay for the services of a so-called turnaround company, Barron's Mead Consultancy, who went on to charge her extortionately for their work. In good faith, she paid them over £6 million in costs and fees, only to discover from a well-placed whistleblower inside Barron's Mead that far from working in her interests, they were taking her money whilst colluding with Lloyds to put Ms Davey out of business and into administration. Sadly, Mr Deputy Speaker, in the 18 months I've been trying to help Ms Davey, and since the last debate on this topic, nothing has progressed. Ms Davey is still being pushed through bankruptcy processes which she shouldn't have to face. Like the constituents of other members in the House and other people mentioned in the debate so far, Ms Davey has found her life left in ruins. Her mental and physical health have both been hit. She tells me that her well-being has been further disregarded by Deloitte, who took her to court during a time when they knew she was the sole carer for her mother, who was dying from cancer. And just a few weeks ago, Ms Davies' office was broken into, with 2 laptops stolen and the server having been tampered with. Mr Deputy Speaker, the campaign against Ms Davey has been relentless, but there's been no such rigour from the Financial Conduct Authority or the police to bring whom she believes to be the real perpetrators to justice. Ms Davey may not have known the true course of events that led to the demise of her businesses had it not been for a whistleblower who in 2013 alerted her to what was being done to her companies. Clearly, whistleblowers are invaluable in calling out immoral and frankly criminal acts such as those detailed here, but we urgently need legislation which protects whistleblowers, as other colleagues have already outlined, and the public by deterring and preventing situations like this. The Public Interest Disclosure Act has failed to protect the whistleblower or address the concerns that they raised, and it's high time that an independent structure was put in place to vigorously regulate the banking industry and protect the whistleblowers to prevent further cases like Julia's. It is greatly worrying that banks and their advisers can operate so unethically, employing turnaround companies to act on their wishes to liquidate a company, whilst posing as being a supportive business, and for there to be no accountability whatsoever. In my constituent's case, the turnaround company, Baronsmead, is not covered by regulation, as it does not fall within the remit of the FCA. Similarly, not all of the activities of Lloyds Banking Group come under their watch. I'd be grateful if the Minister could comment on how and when new regulations might be brought in that would provide oversight for all the operations of banking groups and the companies they employ. I would also like to know why the FCA are not investigating this as a genuine whistleblower complaint 8 months after receiving the information. The whistleblower has provided extensive evidence of the wrongdoing involved. However, my constituent feels that the FCA have blocked her questions about an investigation and allowed the cover-up from the bank to continue. The whistleblower first came forward, as I mentioned, in 2013 to raise the concerns of the manipulation of Ms Davies' companies by Lloyds Bank and their agents, but this was not acted on. It was only after Whistleblowers UK entered the picture in November 2018 that a meeting was arranged between the FCA and the whistleblower. Ms Davies' case was then referred from the FCA to the National Crime Agency, but since this point the FCA have not answered questions about what investigations might be going on with the NCA and using the Federal Information Security Management Act, FISMA, as a shield. I would like to ask the Minister why no information is being provided to my constituent, her advocates or the whistleblower, and further what can be done to ensure the FCA act on this serious matter. I understand from Whistleblowers UK and their Chief Executive, Georgina Halford-Hall, that there is concern that when the FCA does get involved in cases such as this, it is seen to be an ally of the financial services rather than an independent regulator, and that processes for complaints are designed to stifle information that could lead to prosecution. Staff at the FCA have told Whistleblowers UK that they have a responsibility to ensure there's not a run on the bank that might impact the UK economy. This would not be a problem if whistleblower intelligence was acted upon. What we have here, Mr Deputy Speaker, is a public interest issue of extreme importance. Members of the public, especially SME owners, must be aware of the malpractice that can happen in the banking industry and, most importantly, be protected from it. I look forward to the report from Whistleblowers, the report that Whistleblowers UK are due to release later this month, which I'm sure will be very helpful in this area. Mr Deputy Speaker, I'm grateful to have the opportunity to present Ms Davies' case to the Chamber, but I'm disappointed that I have had to do so. This case has dragged on for years, and in that time Ms Davies has ensured repeated attempts to smother her case, as well as attacks on her health, her private information and her personal property. She has gone from being a successful small business owner who trusted a bank to uphold their professional and moral obligations to someone being forced through bankruptcy procedures and desperately fighting court case after court case. The serious injustice of the million shares lost must be addressed and stringent regulation brought in so that no further hard-working business owners fall victim as she has, and I look forward to the Minister and the Shadow Minister's responses in due course, sir.
Stephen Kerr.
Thank you, Mr Deputy Speaker. Let me say that before I say anything that I should declare an interest as the co-chair of the all-party parliamentary group on whistleblowing. Can I say that I was very impressed again with the speech delivered by the Right Honourable Gentleman, the Member for North Norfolk. It was compelling and it was, I think, comprehensive in terms of an argument for the law to be reviewed. It is absolutely vital that we keep whistleblowing laws, protections, public interest disclosure laws up to date and relevant in an ever-changing and fast-moving landscape. The Government, I hope, the Minister, will listen very carefully to the arguments that have been presented thus far in this debate. I believe that there is a case, a very strong case, to be answered in relation to the motion that we're debating today. And I hope that we will hear a considered response from the Minister, who I know well is extremely conscientious in her duties as a Minister of the Crown. Can I also say that I was hugely impressed, as ever, with the speech by my honourable friend, the Member for Thirsk and Malton. And the thing that surprises me, Mr Deputy Speaker, since becoming a Member of Parliament and having to look more closely at the performance of regulators, is how thoroughly inadequate most of the regulators in this country are at regulating the things that they're supposed to be regulating. There is, at times, all too clearly, an unholy relationship between the people who staff the regulator and the industry that they're supposed to be regulating. And that stifles the tension that there has to be of necessity between a regulator and that sector or industry or whatever is being regulated. Now, I mentioned a few minutes ago the APPG, and we do indeed plan to publish a report very shortly to identify how the law fails to protect whistleblowers of any type, and I deliberately stress of any type, because the law as it stands currently does not protect whistleblowers of any type. And the APPG has been consulting a whole range of groups to recommend positive, effective and practical proposals for change. And we hope to learn from other countries as we aim for a best-in-class legal framework. I believe that this is one of the aspects of a competitive advantage that we should be claiming for the United Kingdom in terms of our economy and how we treat those who feel driven by conscience in most cases to speak up, to raise concerns, to do the right thing for the right reasons. Yes.
I thank the Honourable Member for giving way, and I commend the Honourable Member for Stirling and the APPG for the excellent work they do in this field. Prior to this debate, the Hospital Consultants and Specialists Association wrote to me. They referred to a recent staff survey, the NHS, and they said that only 20.8% of respondents felt safe to raise their concerns as whistleblowers. So I agree wholeheartedly with the powerful contribution that the member is making.
That intervention, because it does underline the fact, and it is a central purpose of the APPG, that we need to improve the overall perception of whistleblowers and the attitude towards them.
Given way, and I apologise for being a bit late when he started his speech. So members that have been here a long time will remember the case I had of a consultant called Matu, and he was a whistleblower, and he was suspended. He was never really employed again by the NHS, and it cost, you can take a guess in relation to the figure, probably something like 3 million, and it ended up in the courts, and they tried to use my letter against that individual. So on the one hand, we encourage whistleblowers, but we do nothing to protect them, and sometimes we try to destroy their reputations.
I'm grateful for that intervention. I think I remember a debate we had in Westminster Hall where this case was highlighted. So we will publish our first report in a series. It's a very ambitious work schedule that we've created for our all-party parliamentary group, but we're going to publish a primary report on the first-hand testimony, based on the first-hand testimony of whistleblowers, and that should be published soon. And I'd like to take this opportunity, because I see so many people in the chamber who have been of such support to the work of the APPG, who have served on the panels that we have put together to receive this evidence and witness testimony. So I'd like to say thank you very publicly to the members who have been willing to do that. We've also worked alongside Whistleblowers UK, who specialise in supporting whistleblowers, and I pay tribute to the work that they do and other organisations do in this area. But most importantly of all, I would like to thank the whistleblowers themselves. And I have found that the whistleblowers that we have had come before us to give testimony, they have proven to me to be caring and principled members of society who have put themselves at considerable risk to call out malpractice and misdemeanour. And some of these people are not covered by the current whistleblowers' protections and law. Many were, but some were not. And in the last 12 months, in fact, in less than 12 months, we have heard and collected over 400 pieces of individual evidence to contribute towards the series of reports that we will publish. Many of the testimonies, Mr. Deputy Speaker, were very difficult to hear. And I'll tell you why. Because these are people that put everything on the line. They didn't realise at the time they first spoke up what it would involve, and reference has been made to that by others who have spoken so far in this debate. But having begun the course that they started off on, they have stuck with it, and I have absolutely nothing but total admiration and respect for these people. They have suffered mental trauma, loss of their career, loss of their businesses, persecution of their families, stringent gagging orders, all in the name of blowing a whistle on crime, corruption, negligence, wastefulness and cover-ups. And many of these people are not employees. They are service users, bystanders, parents at school, patients at hospitals, suppliers, customers and taxpayers. But whoever they are, we should be grateful for whistleblowers. They saw themselves as doing their job, doing their duty, doing what was right. And they did the right thing to uphold what they thought was the right standard, the professional standard. They thought they were acting and would probably be praised and recognised for speaking up, doing the right thing, protecting people, protecting reputations, organisational reputations, individual reputations, and standing up for the public good and public confidence, particularly in relation to our public services.
And would you accept that the public sector really is sometimes the worst offenders? I had a firefighter who reported his hierarchy. I won't go into it because it's subject to legal action. Sent it to the police, who then sent it back to the same fire service that he was reporting. That's the public sector for you. Unbelievable.
What I've discovered is that this is a common characteristic of how these whistleblowers and what they raise is treated. What they have raised in anonymity and in confidence is then disclosed to the very body that they're raising the concern about, and because of that they're very easily identified, and what follows is deeply, deeply unpleasant. Not even to hear about it is deeply unpleasant. To experience it must be something else. So I do agree. Whistleblowing in a work environment, in the public sector, should not be difficult. But the truth is, it is. And it's up to this Parliament to change that. Without whistleblowers, we wouldn't know about Gosport Memorial Hospital, or Cambridge Analytica, or LuxLeaks, or the behaviour of Jess Staley, the CEO of Barclays, or the Mid-Staff's NHS Trust, or Rotherham's grooming gangs. These are issues that make headlines, but there are many more cases that probably members in this chamber are aware of in their constituencies from all over the country and across all kinds of sectors, activities, public and private. Bringing these issues to light, while difficult, is undoubtedly a better way, is providing a better way for companies to work, for services to be delivered, and for justice to be served.
Thank the honourable member for giving way. He's making an excellent speech, and it's been very good to work with him in applying for this debate. But does he agree that both those cases in the public sector that the honourable member has mentioned, but also in financial services, as the honourable member for Thirsk and somewhere else, as Walton has mentioned, when one compares the outcome for those brave people whose lives, as he says, are destroyed, with the people who have been guilty of the wrongdoing in the banks, who still continue to earn a fortune and who no one has touched for their wrongdoing, despite the devastating impact that they have had on our economy.
Again, Madam Deputy Speaker, grateful for the intervention of the Right Honourable Gentleman. Whistleblowers are heroes. They're not villains. But sometimes there are villains in their stories. But whistleblowers should be treated with respect and listened to. Sometimes whistleblowers are looking for no more than validation of what they have brought to the attention of authority. That's all they're looking for. Now, whether whistleblowers should have some kind of financial reward or whatever, I see that as a side issue. The real issue is how whistleblowers are perceived and how they're responded to. Let me mention one aspect of the consequence that follows whistleblowing. Yes.
Just as Philippa Whitman raises the issue of having a financial reward, does he not consider that that might actually make the personal situation for a whistleblower within a workplace actually worse, because then it becomes very easy to ascribe a financial benefit that they're after, as opposed to the altruism that is genuine?
I completely understand that point. I'm very, very sympathetic to that. What we need to do is we need to work together to establish this independent office of the whistleblower, because sometimes as a result of the consequences of the whistleblowing activities of an individual, they pay such a heavy price in terms of the financial consequences that flow from their behaviour, from their actions, that perhaps there is a case for some kind of compensation. But I have not made up my mind on that, to be honest. And I think we have to hear more evidence and have a wider discussion in Parliament about these issues. But what I think is absolutely clear is that whistleblowers need somewhere safe to go to be supported and to have their case properly advocated in the face of power, authority and bureaucracy. So I was mentioning blacklisting as a problem, and one person told us how he had been blacklisted for speaking up. They'd reported criminal activity to their employer, and instead of dealing with the issue, the employer dealt with the person who had spoken up in the first place and coerced them to stay silent. It's bad enough to have something criminal going on within your business, but then to cover it up and contrive to force those who were willing to speak up for the reputation of the organisation or the business, to have them do nothing, but force them to leave, that's clearly unacceptable. And then to seek to blacklist them so that they don't get to work in their profession where they've trained, qualifications, that is truly shameful. The complex legal framework around whistleblowing covers too few people. And it is complex and it's legalistic. And many of the whistleblowers we met were not recognised as whistleblowers under law. The tests that are necessary to stop people abusing whistleblowing are too stringent, and they don't recognise complexity. Now, one person who brought up issues of racism at work and the flouting of HR rules, their employer, instead of recognising the whistleblowing, tried to diagnose a mental health issue in the employee, sending the employee on medical leave. And the company appointed psychologists then broke confidentiality to speak with the managers of the business, despite regulators confirming this person had a point. They were dismissed and have received no justice. Whistleblowers can be dragged through courts with mounting costs and unending hassles. For many of their cases have consumed their lives. And it may be thought that the best advice you could give such a person was move on and forget it. But that's not justice. That's unjust. And while that might be said to have been good advice, well-intentioned advice, is that really the way we wish to see the affairs of our country? Economic, public service? Is that how we want them to be dealt with in this place? I really don't think so. But it's equally important, and I repeat this, not to limit the definition of whistleblowers to only be employees. I mentioned earlier whole categories of people, as was mentioned by the Right Honourable Gentleman Member for Norfolk North, who should have the protection that whistleblowers are legally entitled to. And we must ensure that when whistleblowers blow the whistle, they get proper protection under the law, and the law is too vague in this regard. And an individual facing the full force of a corporate or public sector legal department, it's a complete mismatch. Public corporations should be mandated to disclose legal costs to shareholders in such cases. And the same should be true of public authorities. They should have to make clear and report transparently the cost that the taxpayer bears in fighting whistleblowers. And some of the estimates that, of the costs that have been incurred by public services, Madam Deputy Speaker, are absolutely mind-blowing and wholly disproportionate. One brave whistleblower in Scotland had evidence of HR malpractice which should have been a simple grievance dealt with by the organisation they were in. They should have been pleased in that organisation to have received the feedback that this person brought. But instead, that person and their family, who also worked in the same place, were victimised. They can't afford legal representation. They're going to have to argue their own case in a tribunal against a public sector legal department with an expansive budget.
Kerr. And I thank my very good friend for allowing me to intervene. It seems to me that the very best companies, corporations, organisations should have in their ethics or in their code of conduct a requirement on employees or people for whom they have responsibility to report things that are wrong, in the first instance within the organisation, but if they still feel they haven't got satisfaction, they should have a device within the company's organisation to report it, and they should not be victimised for that. They should be applauded, because if they do that, the company will get better.
I completely agree with my honourable and gallant friend. I cannot understand how any organisation would not embrace the feedback that someone brings them when it has to do with the nature of the types of things that whistleblowers will raise. Why on earth would any business or public sector organisation not want to know when things are not being done right? Right in terms of the law, right in terms of what's morally right, right in terms of the values of the organisation. And there absolutely should be a no recriminations policy in any organisation that's worth its salt. But I absolutely believe that there needs to be a place that whistleblowers can go, where they will be in a safe harbour, where their case will be properly treated, respected, and where they will get the necessary level of support, whatever that support might be, so that their case can be properly heard. Madam Deputy Speaker, I think I've made it clear that I really believe that no organisation of any repute should be operating in the ways that we've heard discussed in this debate by various colleagues this afternoon. Governments and companies should be confident enough to know when they are wrong, and they should be honest honest enough and brave enough to address it. And the reaction to whistleblowing should be to say, thank you. Thank you for speaking up. And then when the whistleblower's words and evidence are evaluated, they should be more than happy. In fact, they should be recognising and rewarding themselves, whistleblowers, who will speak up, so that the changes that flow from that will mean that they themselves as businesses or public service organisations can become more efficient, effective and ethical in the way that they operate. So, Madam Deputy Speaker, the APPG will soon publish its findings and recommendations, and we will further consider and promote the case for an independent office for the whistleblower, giving protection and advocating for the interests of whistleblowers. We shall also be asking for an end to the use of non-disclosure agreements to cover up wrongdoing, criminality and other morally dubious behaviour. That idea must be fully debated and explored, because there are currently far too many abuses of NDAs. Parliament and government have a responsibility to set the conditions and the standards. We have to create the culture in our country where people feel confident that they can and should speak up in the public interest. We want whistleblowing recognised as a positive and public-spirited thing to do. And I look forward to the Minister's reply today. But this is the start of the debate on this issue, not an end. And we must recognise the courage and integrity of people who do the right things for the right reasons, because they are guided in what they are doing by conscience and in the public interest.
Yeah. Justin Mathers.
Thank you, Madam Deputy Speaker. And can I just follow on from what the Honourable Member for Stirling said? I think it was a very wide-ranging speech, and I think he's right that this is the start of the process, not the end of it. There is clearly a need for significant legislative reform, and I'd like to thank the Honourable Member for North for getting this debate underway, and for the consistency he has shown over a number of years in supporting those who blow the whistle, and indeed how he set out today why there is a need for a fundamental review of the regulations. It's been clear for some time that we're simply not protecting people in the way that I think that we would all like to see. We've had piecemeal reforms, often as a result of case law, which have given some notable advances in protection, but it also has left gaps and loopholes, and actually it still remains the case, as we've heard on a number of occasions today, that the best run organisations with the most comprehensive policies in place can still be a very daunting place for someone to blow the whistle in, and it doesn't come without consequences. And I know, from my own experience as an employment lawyer before I was elected to this place, about the issues that employees face across a range of sectors when they are brave enough to speak up, and we cannot underestimate how difficult it is and how brave people are when they decide to blow the whistle, because there are so many examples of how people have suffered with careers destroyed and worse as a result of sticking their head above the parapet. Anything from being shunned by colleagues to being dismissed on spurious charges. There are a number of unfortunate consequences that can arise from blowing the whistle, so we really should absolutely support those who have the bravery and courage to do that. And sadly, as we know, the kind of treatment that some people receive whilst in unemployment can continue beyond it, and it is from far the benign environment that we would like to see. So we're having new laws in Ireland and Australia, a new EU whistleblowing directive coming in 2021. So the challenge for us, if we are to ensure that workers' rights keep pace with the EU at least, which is what the government, I think, have committed to, then we must begin to really think about how we can strengthen workplace protections for whistleblowers. And I've spoken before about whistleblowing in the NHS and the importance of providing a workplace environment where NHS staff are able to raise concerns about things they're worried about, an environment where there's no fear of repercussion or unfavourable treatment, and where staff feel confident that action will be taken to resolve their concerns. I'll give way.
Thank you. As my friend from Elswood knows, the Department of Health is based in Leeds. One of my constituents
whistle blew about DH 2020 process in her role as a trade union representative. She wasn't supported. She was actually hounded out of the job she loved incorrectly and won employment tribunal. But that is no compensation to her, because she's no longer in that job, no longer in that role, and has had her career ruined by whistleblowing on behalf of all the employees in the Department of Health who have been affected by DH 2020.
I thank my honourable friend for his intervention, and he raises a very important point, something I will come on to later, that the way that the legislation works at the moment, it is retrospective, it is righting wrongs after they have occurred, and as we've heard and as we'll hear again, I'm sure it's really too late to put a career back in place after the event. And in the NHS, it's particularly important that people feel able to blow the whistle safely, because not only do they have general obligations as an employee, but also many staff have a professional duty to raise concerns where they sit and could actually be in trouble with their own regulators if they don't. And you know, NHS England and NHS improvement policies are very clear on this. They say, if in doubt, please raise it. Don't wait for proof. It doesn't matter if you turn out to be mistaken, as long as you are genuinely concerned. And the NHS Constitution pledges that NHS employers will support all staff in raising concerns. Clearly, as we've heard today on a number of occasions, that hasn't happened, because fine words are not enough. Sadly, actually, we see staff don't have the confidence to raise concerns without fear of repercussions. The most recent NHS staff survey, when staff were asked if they would feel safe raising concerns about unsafe clinical practices, found that only a fifth said that they strongly agreed that that was the case, and 3 in 10 said they did not feel safe in raising such concerns. And when asked whether they were confident that their organisations would address their concerns, just 14.8% of staff strongly agreed with that statement. And when this is considered in the context that 17.8% of staff said that they had seen errors, near misses or incidents that could have hurt patients in the last 12 months, it should be deeply concerning to all of us that staff in the NHS do not feel that their concerns are acted on. And as the Honourable Member for Norfolk North mentioned earlier, Junior Dr Chris Day was a very prominent example of someone who blew the whistle and was treated then appallingly. He raised legitimate concerns about staff ratios, but then lost his job. The tribunal action which followed resulted in a lengthy, and I consider a wholly unnecessary, legal battle where Health Education England were effectively seeking to remove around 54,000 doctors out of whistleblowing protection by claiming that they were not the employer. 4 years and hundreds of thousands of pounds later, they eventually backed down and accepted they should be considered an employer after all. I'll give way.
I'm very grateful to my friend for giving way. Is he aware that a contract which was between Health Education England and trusts, which demonstrated the degree of control that Health Education England has over the employment of junior doctors, was not disclosed for some 3 years in that litigation. And it was drafted by the very law firm which was making loads of money out of defending the case against Chris Day. And when I raise this with Health Education England, they won't give me a proper response because they say the case is at an end. Does he agree that this is totally unacceptable and that it smacks of unethical behaviour by the law firm to make money out of not disclosing a contract that they drafted themselves?
Thank my honourable friend for his intervention. I think he absolutely highlights a really important point. And well, I will quote what Sir Robert Francis said in response to that. He said, when asked for advice by NHS organisations about issues around public interest disclosure, legal advisors have tended to be influenced by an adversarial litigation and therefore defensive culture. And I think that actually is marked out very clearly in this particular case. And so at the end of the litigation, Health Education England said, and I quote, having never wished to do anything other than facilitate whistleblowing for doctors in training, HEE is happy to be considered as a second employer for these purposes if it removes a potential barrier for junior doctors raising concerns. Well, we've heard very clearly that concern was not manifested itself for at least 4 years during the litigation. So why did it take them so long to accept that this should be considered an employer? And what message does that send out to NHS staff about the corporate attitude to whistleblowers? It is hardly encouraging. And whistleblowers are a vital safeguard when all other systems have failed. And as my honourable friend mentioned earlier on, there are a whole litany of cases where actually if whistleblowers had been listened to earlier, lives could have been saved. Gosport, Morecambe Bay, Mid Staffordshire, Bristol Royal Infirmary are all examples of that. And the Francis report did thankfully shine a light onto some of the completely unacceptable treatment that NHS staff have experienced. And I quote from one individual who fed into that report. They said that finding employment is proving very difficult, and I question whether any of it was worth it. Another said, I've often been so depressed by this experience that I've often considered suicide. Damning words, Madam Deputy Speaker, damning words indeed, and I think that is a shame on us all that people feel that way for having done what we all think is the right thing. So I do acknowledge, however, there have been some progress and protections afforded to NHS employees in recent years, particularly as a result of the Freedom to Speak Up report and the regulations brought forward by the government about future employment prospects from whistleblowers, but there are some issues that I remain concerned about. One is protection for other workers who support whistleblowers, and it's easy to envisage, particularly if you've got a team of medical professionals working on a particular issue where two or more employees might actually notice an issue of concern together, but only one of them actually makes the disclosure. So I've raised this with the Minister previously, and at the time it was made clear the only remedy available to that second person or associated party is to register a grievance under their employment's grievance policy. I don't think that is actually strong enough protection, and we do need to recognise that people do work in teams, and actually unity is strength, and collective arguments are always better. So I think we do need to look at how we can strengthen protection in those situations. And another issue which we've already talked about and touched upon is how actually someone who's lost a job can take their employer to an employment tribunal and seek redress, but the onus is on them to prove that it was the disclosure that lost their job. So the Hospital Consultants and Specialists Association has come across cases of employees facing action after speaking out based upon different circumstances than their whistleblowing case, but which appear to be clearly linked. So these can be very subtle actions, bullying, harassment and undermining, being overlooked for opportunities for promotion, or feeling, just a general feeling that the employer is looking for a reason to act against them. Such instances are of course impossible, virtually impossible to prove, but they contribute to that climate of fear that whistleblowers have, and fear that they're only as good as their next mistake. And we cannot allow continue to allow promising careers to be left in tatters as a result of ineffective whistleblowing protections. We've got to send a much stronger message to employers that disclosures should be protected as the legislation intended, and people who make those disclosures should not be attacked in any way whatsoever. And as we've already touched on, I think by its very nature the legislation only gives a person protection after a detriment has been suffered, and it's often too late by then. A dismissal, a career destroyed. No tribunal can fully rectify that situation, and it's actually quite disturbing that the success rate in whistleblowing claims that reach tribunal is only 3%. I mean, that really does bring quite clearly how easy it is, I think, for employers to use parts of the legislation to avoid their responsibility. I don't know of any other tribunal jurisdiction which has such a low success rate. Certainly if I was still practising, I think if I had a success rate of 3%, I wouldn't be in a job for very long. But it does show why we really need to understand how this legislation isn't working as well as it could do. And of course, as we've already talked about, most employers are in a much better position. They're able to rely on expert legal advice. They can put forward alternative allegations and reasons for treatment alleging misconduct or redundancy. There are too many hoops to jump through and too many opportunities for employers to argue that the disclosure doesn't count as one under the legislation, and that removes, of course, the employer's protection altogether. And I think it's wrong that it's not enough for an employee to rely on his own assertion of subjective belief that the information tends to show a breach of the regulations, and that leaves them at the mercy of the roulette wheel of justice, for them potentially having to wait many months before they can even know for sure whether their disclosure will have full protection under the law. And whilst we're looking at how the laws operate, and I think we also need to examine whether the protected conversations that were brought in under the coalition government are working in the way that they were intended to. Because, of course, you can have a protected conversation with someone, not mention whistleblowing at all, but you might have had a conversation or a potential disclosure raised earlier on. And if you're the employee in that situation and you're being told that there's a payment to leave the employment, it's a very, very vulnerable situation, and you really are not going to know for sure whether your disclosure would count. So I think we need to see whether there is any correlation between protected conversations and disclosures made under the Whistleblowing Act. So in conclusion, Madam Deputy Speaker, whistleblowers shouldn't just be protected, they should be venerated for the role they play in defending the safety of others. Nobody making a disclosure wherever they work should do so in fear or with the risk of having their livelihood taken away. The whole culture of workplace protection in this country is one of extreme disposability, be it temporary or agency work, be it 0 hours contracts, or just the ease by which people can be dismissed. This does not lend itself to a healthy environment where people feel confident and secure that they can speak out without fear of reprisal. The truth is that we have allowed a situation to develop in this country where job insecurity is considered to be just part of the landscape, and that has to change. We owe it to people to ensure protections are as effective as they can be, and that is one of my tests for a decent and civilised society, and it's a test at the moment I believe that we are comprehensively failing.
Annalise Dodds.
Thank you very much, Madam Deputy Speaker, and it's a real pleasure to follow on from my friend for Ellesmere Port and Neston. I was very impressed by the hard work that he's done to actually match up, sadly, the reality of NHS practice with what is written on paper in terms of its policy, and to think through the implications of that for patient care. So thank you. I'm grateful to the member for that. I'm also grateful, of course, to the Honourable Member for Norfolk for helping to secure this very important debate, and to all of the hard work of the Honourable Member for Stirling as the co-chair of the all-party parliamentary group that I also sit on. And just as he has done, I would like to thank all of those whistleblowers who have been willing to come in front of our parliamentary group to discuss this issue with us. And I'd also like to thank my constituents, and I have had a number, even though I'm a new Member of Parliament, who have tried to blow the whistle. And in almost every single case, their experience has accorded with what has been described within this chamber. An initial unwillingness to deal with the issues and problems that they raised, followed by, in many cases, retaliation, which, exactly as was mentioned in the previous speech, often occurs in a whole variety of ways, which are very difficult to write down and take action against. And in some cases, that retaliation has been really quite extreme. I have one constituent at the moment who had a vexatious legal case taken against them as a result of this. They were cleared, as they should have been, because they had done absolutely nothing wrong, but of course their name is still on the legal record, even although they were cleared, and they believe that's having an impact on their employment. And I think the pattern that was described by the member for Thirsk and Malton in relation to Lloyds is a very, very common one as well. And I just wanted to say for the record that his account very much accords with the account of the Thames Valley Police and Crime Commissioner, with whom I've discussed this case a number of times, and he's rightly very exercised about it, because I think it indicates a continuing lack of willingness, actually, by many to deal with these issues properly. Now, I don't want to speak for very long, Madam Deputy Speaker. I just wanted to comment particularly on the need to reform PIDA and also the NDA regime. And I think that must come after a thorough review overall of the arrangements for whistleblowing, as is urged by the all-party parliamentary group on whistleblowing. Now, as a number of speakers have already said, it is actually very unclear to many whistleblowers who is a prescribed person under PIDA and the Prescribed Persons Order 2014. But even within the category of prescribed persons, I found in my constituency casework that it's often very unclear, actually, whether the scope of interest of that prescribed person, as it were, covers their case. So, for example, if we look at the field of education, the Chief Inspector is able to deal with issues relating to the welfare of children who are living in school-provided accommodation, but they can't deal with, say, unethical educational practice within those schools. It appears that the only body in that case that could be appealed to is the Secretary of State for Education, but then there doesn't seem to be a really clear procedure in that department to actually deal with whistleblowing concerns. And I recognise that this isn't the same department as that of the Minister who sat before us today, but I think government overall needs to make sure that proper procedures are in place, because after all, our constituents are informed on the website that lists those prescribed persons that if they can't find someone to report to and they don't want to report to their employer, then they should take their case to the Member of Parliament. But if we don't know exactly who to then take the case up with and to try and get some resolution, I think that puts us in a very difficult position, as well as our constituents. We really need to have a proper investigation of whether the existing list of prescribed people is appropriate and whether those bodies are adequately prepared. And I think, in addition to that, because of the lack of preparation in many cases, we find that actually regulators and other bodies are very ill-equipped also to separate out vexatious complaints from genuine whistleblowers. There's a huge inefficiency in the system there. We also find that regulators who aren't on the list of prescribed people often aren't aware of and do not understand how to advise whistleblowers about who they should approach. So I found a number of cases where whistleblowers have tried to ask the relevant regulator who's not a prescribed person, what should I do? And they're signposted to the wrong people, they're given duff advice. This really shouldn't be happening, and government needs to grasp the nettle on this and provide coherent guidance. I very much agreed with the Right Honourable Member for Norfolk about many of the gaps here. But of course there's also the issue that was mentioned quite rightly by my friend for Stroud about the fact that often those bodies, including those which have a duty under this regime, are talking to each other in a way that completely contradicts the principles of the legislation, and they are sharing information inappropriately when it's already covered by that PIDA regime. One was mentioned previously. I have had one case of somebody whose case was casually discussed at a semi-social occasion, networking occasion, by a public employee with the employer of that whistleblower. And what makes it even worse is that the case was related to child protection. And we cannot have this situation where kind of almost chummy relationships are leading to that valuable information being inappropriately shared. Secondly, as mentioned, I just wanted to comment on the use of NDAs, and I suppose bring this discussion into line with that around the use of NDAs when it comes to sexual harassment cases. Of course, the Women and Equalities Committee has criticised their use in relation to sexual harassment. And I must say that personally, we should be questioning whether they are ever appropriate, I think, in relation to whistleblowing cases. Actually, the UK legal system, when it comes to libel, is very strong compared to other countries. In fact, those of us concerned about investigative journalism might argue that it's too strong, but it's very strong in international comparison. If untrue statements are made by those who have been whistleblowers, that can be pursued in court by their previous employer or by the body about which the whistleblowing complaint was made. If we're really to learn from the testimony of whistleblowers, then it should not be possible to silence them with NDAs. And I just want to end my speech by, as everyone I think has done who's spoken in this debate, thanking the whistleblowers in my constituency. There are a number of them who I can't name because of the procedures that I've just talked about, but also because they're concerned about the impact on their professional reputation if their name becomes known as a so-called troublemaker. And that's an enormous problem because, as members have mentioned time and time again, actually what whistleblowers provide is a corrective to malfeasance, to illegal activity, and that testimony is incredibly important. And the one phrase that I always think about when talking about that evidence is that it can lead to positive change. And I learnt that phrase from the Oxfam whistleblower, Helen Evans, who was one of my constituents. And the whole process of what happened to her, I think, is very instructive. Sadly, some tried to kind of weaponise the evidence that she brought to the table against international aid, but she's consistently, rightly argued that actually what she and others uncovered was indicating that it was those very, very vulnerable young women and girls who had both been appallingly treated in Haiti, but also who really needed economic empowerment. So she was never arguing against international aid. In fact, quite the opposite, arguing for it. And she has been determined to argue for the fact that this must lead to positive change. I think her example on that and others is leading to positive change in the international aid sector. And those who did not listen to her initially now say they're grateful for her testimony. And of course, that's often the case with these whistleblowers, but they should not have to go through that fight in order to get to that understanding. So we need to have positive change in our public services, in the private sector, wherever there's unethical or illegal behaviour that's going unchallenged. And we should recognise and indeed praise those whistleblowers who help us to get that positive change. Thank you.
Hear, hear, hear. Jim Shannon.
Thank you, Madam Deputy Speaker. It is a pleasure to speak in this debate. Also a pleasure to follow the Honourable Lady for Oxford East. Can I congratulate the Honourable Members for North Norfolk for setting the scene, and for Stirling, and also for Thurston and Malden for making such valuable contributions as other Right Honourable Members have before and will after. They've been engaging in this subject, and they and their APPG are to be congratulated on sustaining their interest and their effort here. Like the Honourable Lady for Oxford East, I would not be happy to make all of the cases that I've been involved with over the years known, because of the individuals that are involved and also because of the organisations that are involved with them. This is in Northern Ireland we're referring to. Health Service, the Council, sometimes the police, and sometimes other organisations, which I won't go into any details, because if I do, that will inhibit the person who has come to me. And I'm always very clear in the confidentiality of that. I want to dwell on one case, if I can, Madam Deputy Speaker, because this case is dragged on for so long. And when I describe the case, and the Honourable Gentleman for Thurston and Malden will know it, therefore he will know the case, he will know the person involved, because he's directly involved in this case, or has a knowledge of that person in particular. But let me begin by saying a review of the 20-year PETA is welcome and necessary to ensure that UK remains the best place in the world to do business. Piecemeal reforms, often as a result of individuals bringing claims, have extended the scope of who is now protected, but there does remain, unfortunately, gaps and inconsistencies. The Government recently committed to ensure that workers' rights keep pace with those in the EU, whatever the Brexit outcome. This is an opportunity for a reiteration of the commitment to ensure worker protection does not fall behind in the coming years. I feel I can say this for a few reasons. Within my constituency, I had a constituent who was engaged in the longest running employment tribunal case at the time, from 2007 to 2012, and had some 50+ tribunal days. So an absolute endurance test for him. And I have to say what it led to him. It led to his substantive mental health problems and a complete breakdown physically and emotionally. And my parliamentary aide and myself supported the employment tribunal process for some 18 months while he recovered, and we helped that gentleman and his family. So sometimes we need to be really aware, Madam Deputy Speaker, of the impact that it has on the individual who does the whistleblowing, but also the impact upon the family, financially, emotionally and mentally. And I'm very clearly in this case, this was horrendous what this gentleman went through. In the end, here's the end of it. The Employment Tribunal found he had made 12 protected disclosures involving going concern matters for the UK company and intangible asset valuations which could not be justified. Does this sound familiar? Carillion, BHS in 2018 and 2019? If you learnt a lesson, Madam Deputy Speaker, would not be great, but they don't learn a lesson because it seems to happen over and over again, as has been explained here today. Why I make this point is that during these 18 months, I and my constituent on occasions engaged with the FRC on an investigation into his disclosures. The FRC and the ICAEW investigations were lamentable, and in fact I noted that the FRC CEO recently refused to disclose what whistleblowing investigations have been undertaken in the last 10 years in response to the BEIS Select Committee audit inquiry. During the same time in 2011 and 2012, the BEIS had a consultation to the Sharman inquiry on going concern in late 2011, to which I made as an extensive contribution at that time. Those 30+ responses have all been removed from the FRC website, and once again, 8 years on, we have had another BEIS FRC consultation on going concern. Will this accounting profession ever get it right? While concurrently, Bees issued a consultation on the reform of the FRC in November 2011. At the same time, in December 2010, the FSA and the PwC conduct an independent inquiry into RBS in which their press release stated, "The issues that we have investigated do not warrant us taking any enforcement action either against the firm or against individuals." How disappointing. The FSA cannot publish the content of the RBS review as information gathered from the bank during the course of the review remains confidential under the Financial Services and Markets Act of 2000. 8 years later, and last month, we had a further report from the successor of the FCA, which disappointingly essentially concluded the same. I'm very happy to give way.
Giving way, he's mentioning the FCA and he's mentioning the FRC. There is an opportunity with the change that's now coming to the FRC that we can break away from what the pattern of performance has been in the past. There is an opportunity for us to disconnect with that past. Would you agree with me that it's vitally important that whatever replaces the FRC, it is not continuity FRC?
From Stirling for his intervention, yes, I absolutely agree with that. I don't think there's anybody in this House today, and maybe outside this House, that doesn't agree with just what he said. Continuity wouldn't be what we want, it's change we want, and the quicker the better. Concurrently, Paul Moore, the HBOS, I can mention his name for you, I've got his authority to do so, whistleblower in my constituent, met with the TSC chairman, now Lord Andrew Terry, MP, in February 2011. We were delighted to learn, as subsequently published, that the TSC would look to engage independent assessors reporting to the TSC for some of their future investigations. This was announced and reported on the front page of the business section of the Daily Telegraph on the 5th of May 2011, followed up with subsequent inquiries. Yet only days ago I read again. Commenting on the government response to its excellent report on the future of audit, Rachel Reeves MP, chair of the Bees Committee, stated, and I quote her, "The collapse of Carillion and accounting scandals in Tesco, BT and Patisserie Valerie and others have provided a painful lesson that audit isn't working. Businesses, investors, pension holders and the public deserve better. Urgent audit reform is needed, not yet further consultation." Exactly what the honourable gentleman is referring to. The CMA and Bees Committee's extensive inquiries on audit proposed a range of practical recommendations to improve competition, tackle conflicts of interest and improve the culture of challenge in audit firms. The response to our report suggests that government is in danger of kicking vital audit reforms into the long grass. And then they'll get lost and we'll forget about it for again. That cannot happen. We should not wait for this next corporate collapse. Government needs to ignore the lobbying of vested interests in audit and set out a very clear timescale for delivering on the substance of the CMA and the Bees Committee's recommendations. Listen to what the chair of that committee says. So were things different in 2019 for audit and whistleblowing than my experience of 2011 and 2012 when I first came into this House? No, nothing has substantially changed yet. And yet whistleblowers regularly provide an early warning sign when things are going wrong, often dubbed the canaries in the coal mine as one of and they can help avert a future scandal. They can save organisations money. 1 in every 3 serious economic crimes was highlighted by a whistleblower, according to a recent survey. This makes whistleblowing more effective than all the usual watchdogs combined: corporate security, internal audits and law enforcement. In addition, we need a regulator who is willing and able to listen to whistleblowers who come forward, to protect them from retaliations. Research by Professor Kate Kenny from Belfast, Queen's University of Belfast shows that the cost of whistleblowing can still be very high, both financially, both personally, physically and mentally. I witnessed that up close with my constituent and his family. For a healthy economy and a reputable financial sector, we need to start supporting whistleblowers. Finance has never been more difficult to regulate because it incentivises people to chase excess profits, even at the expense of ethics and the long-term survival of an organisation. It remains acceptable, in many cases profitable, to remain silent about wrongdoing. We need to encourage whistleblowers. What this all means is that a significant shift is needed, starting with helping employees to speak up. Otherwise, the financial sector and the remainder of the economy remains at risk of another crisis, and we may be asked to foot this bill just like the £1 trillion from the last time. In that regard, as party, the DUP, my party, have been very active in supporting the APPG and fair business banking and victim support groups, such as the SME Alliance and also the CYBG Remediation Support Group, and pressing Her Majesty's Government and the banks to put in place a voluntary redress scheme for SMEs, which is truly independent. Wow, would that be great? And it can address the unintended consequences of light touch regulation enabled through FSMA 2000 and the abuse of SMEs. Finally, Madam Deputy Speaker, bank redress process is beginning to take shape. So will the Minister make a similar commitment to address much more effectively the future of audit and renewed vigour in updating our whistleblowing legislation? Like the banking redress for SMEs, they too are important matters for our economy post-Brexit. And the original Peter whistleblowing legislation has its genesis some 20 years ago. And I will therefore appropriately finish by restating some other comments. A review of the 20-year PETA is necessary to ensure that UK remains the best place in the world to do business. That's why it's important, the best place to do business. Piecemeal reforms, often as a result of individual bringing claims, have extended the scope for who is now protected, but there remains gaps and inconsistencies. Government recently committed to ensure that workers' rights keep pace with those in the EU. This is an opportunity for the Minister to reiterate a commitment to ensure worker protection does not fall behind in the coming years. And as a party, the Democratic Unionist Party, part of the partnership with the Conservative Party and government, we support the commitment in relation to updating our whistleblowing legislation in a post-Brexit Great Britain and Northern Ireland. Madam Deputy Speaker.
Dr. Philippa Whitford.
Thank you very much, Madam Deputy Speaker, and I too pay tribute to the member for North Norfolk in leading on getting and opening this debate, and the other members of the APPG for the work that they're doing on this topic. Bristol Royal, Mid Staffordshire, Morecambe Bay, Liverpool, Gosport, Wharton Hall. These are all shocking scandals of health and social care. And in every one of these scandals, there was a whistleblower, years before it came out, who tried to raise concerns, who tried to protect people. They were ignored, and that's often the least that happens. They are often undermined, victimised, or dismissed. I will, yes.
Thank you, Madam Deputy Speaker. Maybe the Honourable Lady was going on to say, I suspect she might have done, that they were then blacklisted and they couldn't get another job in the health service after that for some reason which they could never actually ascertain.
I thank the honourable and gallant gentleman for his intervention. But what is clear is that we are advised by the GMC, obviously as a medic myself, Royal College of Nursing, various official bodies, that we must speak up. We have a duty to speak up. And yet the landscape we look at is littered with broken careers and often broken people. And the problem is whistleblowers think they are protected. They've heard about whistleblower protection and it simply doesn't exist. The member for North Norfolk talked about brave people speaking up. People shouldn't have to be brave to raise concerns. And the problem is if all you see is people ahead of you who have been driven and hounded out of their career and maybe have ended up with mental health issues or worse, then that is a big, black, threatening cloud. Keep your mouth shut, keep your nose clean, walk by on the other side. And the problem is that results in more suffering and in more death. There are two aspects. We have the aspect of business and industry, represented most commonly by the finance sector, and also public services, most commonly by NHS. And these two sectors, finance and NHS, probably generate the biggest number of scandals and whistleblowing cases. And therefore, they probably require specific treatment in themselves within those industries to actually invite and protect whistleblowers and bring them forward. Now, while finance is, of course, a UK-wide regulation, health services are devolved, and therefore the four health services are struggling with this and are working with this to try and improve whistleblowing. After the mid-staff scandal, Sir Robert Francis highlighted that in mid-staffs, and indeed this was an issue in some of these other later scandals, it was an obsession with becoming a foundation trust. And members, including the honourable gentleman for Stirling, talked about why do people do this? Why do they cover it up? Whether you are a high-profile business or a public service that has been corporatized, there is a drive to remain shiny and perfect on the outside instead of admitting a problem and trying to actually fix it. He obviously came up with his report and set up the freedom to speak up guardians both in hospitals and also the National Guardian. In Scotland, the local within a health board, as we don't have trusts, is a specific non-executive director who is a whistleblowing champion. Now, the advantage of the non-executive is they're at the board, they have a very clear and loud voice, they're not actually an employee, but equally they are part of the system. The freedom to speak up guardians are actually employed by the trust. So they're operational, they are a person to go to, but they're also an employee. So there are issues at the trust and health board level of just how do you have someone who themselves is protected. And maybe you don't just need an independent national office, but something more like an independent system. And in something like the NHS, that might be people who are taking responsibility for safety, for the healthcare services information that was discussed. Unfortunately, the legislation is in the Brexit long grass, but I hope it will eventually come forward. At the national level, there is a National Guardian in England, but they don't have statutory powers. In Scotland, they have set up an independent National Whistleblower Office, and that officer is basically the Public Services Ombudsman. So they're completely separate. They're outside the system. And they have statutory powers. And I think that's actually quite important. And they also set up an advice line, a contact reporting and advice line, and that was back in 2013. So that if people were afraid to report locally or were not getting anywhere, they could report to the phone line. I will.
She makes a very good point about what is just happening in Scotland now, but it is worth saying, in relation to the evidence that we received as an APPG from Police Scotland and NHS Scotland, that the lessons that, for example, NHS Scotland have learned in Inverness, just as an example, these lessons are being taken well on board by public authorities in Scotland. I think maybe the size of our country allows us to do things a little bit more quickly and deftly, but undoubtedly the lessons of the past are being learned and are being implemented, and I applaud NHS Scotland and Police Scotland in that respect.
I thank the honourable gentleman. So small is beautiful after all. That's excellent. But it's true. The evidence is there. The evidence has been there for years. And the problem is action hasn't been taken. The independent whistleblower, they've already developed and published and are consulting on standards that will look at bullying and harassment, which is an issue that has come out in NHS Highland. But they will also look at patient safety issues. They can empower reporting and review. It includes primary care and social care. It includes not just trainees like Dr. Chris Day, who was appallingly treated, but also students and volunteers, because no one should be limiting and excluding the person who saw bad and dangerous behaviour from coming forward and doing something about it. And finally, the standards include, and every health board will have to report on, the actions they have taken to remedy the findings of the investigation. So they must investigate, they must record how they investigated, they must record the action they took, and they must show any improvements that they have developed from that investigation. Statistical analysis will be part of an annual report in the board every year, and that will look for themes and trends and patterns. So it is, and I welcome that the honourable gentleman for Stirling recognises an attempt to actually make this work by having an independent office. And in the survey of health and social care staff in Scotland, and it is health and social care staff now, in contrary to what members here have said in England, approximately a quarter saying they would have confidence to speak up, the results showed 2/3 felt they would have confidence to speak up and raise a concern. As a doctor, I'd like to see it an awful lot closer to 100. The Independent National Whistleblowers Officer will also have in their statutory powers the ability to take disciplinary procedure against anyone who victimises a whistleblower. And that is also critical, because at the moment, as we've heard, the whistleblower suffers and the person who caused the suffering doesn't. But regardless of the different nations of the UK trying to tackle whistleblowing issues within their own public services, and particularly their NHS, finance and other UK regulation systems need to be dealt with here. And in particular for whistleblowing, the Public Interest Disclosure Act is the overarching legislation which covers all sectors. It was actually 20 years old yesterday. It was a private member's bill. And so maybe it didn't really have the scrutiny that it should have had. It was groundbreaking at the time. But the UK is now well behind the pack, including countries like Ireland, and frankly, it needs to catch up. All it does, as has been highlighted by the member for Ellesmere Port, it doesn't protect the whistleblower, it only allows them to go to an employment tribunal after they have suffered huge detriment, and with only a 3% success rate. Often the tribunal is used to actually create more damage and victimisation. So what whistleblowers that I've been working with have asked for is an independent, freestanding Public Interest Protection Act, not part of employment law, actually freestanding. And it should do a few things. It must ensure investigating the concern, because the concern often disappears in all the fighting. The whistleblower should be protected from the point at which they raise their concern. It should cover all those who would be in a situation to report, whether trainees or non-workers. It should prohibit detriment, and there should be the ability for civil wrong or criminal offence action to be taken. And it does require an independent agency or body. And it should recover regulators, because it's not just the FCA or FRC. The CQC are in the frame for Walton Hall, that they have done a report that described it as not having a problem when actually people raised issues. So unless we change this, unless we take the heat out of whistleblowing and make reporting normal, like we've done with DATIC systems in the NHS, if we make things not whistleblowing, just part of your normal duty, then we can change that. But whistleblowers must be valued, and in the NHS, it's a matter of patient safety, and that is critical.
Yeah. Shadow Minister Laura Pidcock.
Thank you very much, Madam Deputy Speaker. What an interesting debate this has been. I would like to congratulate all of those brave people who have come forward as whistleblowers. I think there's been so much agreement in this chamber, and I don't think it's just because there's so few of us here. Actually, I think it's because this is a serious issue that we all have a willingness to try and redress. Congratulations to the Right Honourable Member for North Norfolk for applying and being successful in securing this debate. His speech went to the very heart of the question, where people have done a very, very brave thing in reporting abuse. They are subject then to serious detriment. And rather than us concentrating, and this is what I've been amazed by in this debate, all of our energies and efforts on how the process can work best and how swift investigation can take place. Our energy is spent thinking about the whistleblowers' energy fighting and using their energy to fight saving their job, saving their relationship, saving their home, saving their mental health. And that important point on the effect, the knock-on effect, the corrosive effect on how everybody else feels about the system and their willingness to come forward and whistleblow. The case of Dr. Day and the numerous other whistleblowing cases are illuminating and show us that nearly 10 years into austerity and into huge cuts in the public sector and the long-term societal shift towards privatisation leads us to a couple of conclusions. Not only, of course, and I would say this as a Labour member, but that the cuts need to stop. They create dangerous working conditions, often in staffing shortages and skills shortages, and that privatisation of care is inappropriate, but that we need much more robust legislation in the face of these conditions. And the point was made, I think, repeatedly, it was a theme throughout many members' contributions, that power and unequal power distribution in the workplace is crucial, as with so many workplace issues, and legislation must redress that inequality. The member for Norfolk North and Ellesmere Port and Neston also crucially mentioned the necessity for non-regression clauses on EU directives pertaining to workers' rights post our withdrawal from the European Union. And the member for Thirsk and Walton highlighted an important trend that seems to occur when people whistleblow, in that rather than a full and thorough investigation into the claims, disciplinary procedures are used as a silencing mechanism. The member for Stirling paid tribute to the whistleblowers and stressed their selflessness, and I think that there probably is a burden that those people wish to relieve when, selfishly seeing that harm, but the member is absolutely right in that they are doing it to put an end to that harm or that misconduct that they see. There have been so many important contributions. The member for Oxford East talked about the very complex picture for constituents, about trying to understand who the prescribed person is. And if we find it confusing as members of Parliament, people with very busy lives who are not navigating these systems all of the time, it shows that there is actually a failure in the system. Madam Deputy Speaker, for many years whistleblowers have not been given the protection they need or deserve and are left at the mercy of unscrupulous employers and state organisations. There are many victims of that negligence, and it is right, therefore, that the balance did start to shift from 1996 onwards, first with the Employment Rights Act and then with the Public Interest Disclosures legislation from 1998 onwards, and the revisions between 2013 and 15. However, we must be continuously asking in this place whether the protections and support we have for whistleblowers is inadequate in an ever-changing work and political environment. I therefore welcome this debate, and I'll shortly outline some of the principles behind my party's approach. There are currently 3 protections for those who have made a protected disclosure. Firstly, the right to not be subject to detriment as a result of whistleblowing. Secondly, that dismissal, where the principal reason for dismissal is the fact that the worker has made a disclosure, is automatically unfair. And thirdly, that where any other agreement seeks to prevent whistleblowing, that provision within the agreement is void. However, while these protections are important, they do not address the current failures in the law. The gaps allow many workers to fall outside of the scope of this legislation, as well as the failures to encourage the cultural changes, and I think that has been ever present in everybody's contributions, that will promote a culture of honesty and transparency in our workplaces, businesses and organisations, and a culture where whistleblowers are actually celebrated as that public good and forcing organisational change. For example, the failure to cover all workers because of the definition of worker used is a major flaw in the current legislation. That means, for instance, that many self-employed workers, which we know to be a much abused and contested category of employment, are not covered. It can't be right just because someone is employed on a contract which, in the first place, tries to absolve the real employer of their responsibility for the worker, they are also then denied the protections with regard to whistleblowing. Also excluded are most job applicants, and what this means is that whistleblowers can routinely suffer detriment through the recruitment process without any redress because they are known to be whistleblowers. This is surely an anomaly when job applicants have the right to be given protection under the Equality Act of 2010 on grounds of discrimination, harassment and victimisation. In addition, there is little attempt by the government in their approach to whistleblowing to encourage a proactive culture which not only supports the whistleblower themselves but creates the condition where the issues that they disclose are taken seriously in a timely manner and remedies are sought. Where I suppose where is the requirement to investigate, and where are the mandatory enforceable and so important measures to support good practice and cultural change? UK law needs to be much more proactive, with early intervention being prioritised in order to protect both the whistleblower and the public. What is clear is that in recent years we've fallen well behind other countries on the issue. This is hardly surprising, given that the government have an anti-worker stance on most issues, but it was thrown into sharp relief by the recent EU directive, which provides protection for self-employed and requires for organisations with over 50 employees to establish reporting channels. Now, I would like to say a few words on the principles that will guide a future Labour government, which hopefully isn't too far off in the future, on whistleblowing. Our key objectives in government will be to encourage people to raise concerns about wrongdoing, to ensure that such concerns are investigated in a timely fashion, appropriately, and that wrongdoing is rectified, to protect whistleblowers and others affected by whistleblowing, and importantly, to require employers to maintain appropriate procedures which facilitate whistleblowing. Under a Labour government, we would like it to be the legal duty of employers to protect whistleblowers, and that is enforced. And that means all workers, irrespective of the nature of their working relationship, whether they are paid or not, for example, interns or volunteers. Those protections should apply to people who make the disclosure, whether they are workers, former workers, people seeking work, and those undergoing training. And I think I'm right in saying that there is quite a consensus for that. I want to just talk about some of the patterns. As in my role as Shadow Minister, I've been thinking about the experience of the whistleblower and the themes that exist there. And the feedback reports that a typical journey of a whistleblower looks like this. If the worker is inexperienced at whistleblowing, there is uncertainty about what to do and who to tell, as has been mentioned. They often go to the immediate manager. The system response may be poor and include ignoring, minimising the issues, deliberate delays, or hostility and intimidation. The system response may include reluctant, ineffective or biased, tokenistic investigations, deliberate attempts to exhaust and discourage the whistleblower with excessively lengthy and complex processes. Intimidation may increase with severity, with counter-allegations and formal disciplinary proceedings against a whistleblower, or suspension and dismissal. And at this point, this isn't even the full journey. We have to remind ourselves that all they've done is report wrongdoing, misconduct or harm. The whistleblower's future employment prospects are in serious danger by this point. The whistleblower then escalates concerns externally to regulators. The system response is likely to be a full attack by this stage. If the whistleblower has not yet been dismissed, dismissal is almost certain, whether on trumped-up grounds or probably on lawful grounds, on breakdown of employment relationship under the some other substantial reason route. At this point, the whistleblower's future employment prospects likely to be damaged beyond repair. They are unlikely to obtain equivalent employment in the same field again. Regulators, oversight bodies and government departments are often part of the problem and may turn a blind eye to the whistleblower's disclosure and the fact they have been suppressed and victimised. Sometimes they will even outrageously orchestrate the harm and the suppression. And overall, the Public Interest Disclosures Act 1998 only kicks in after the whistleblower has been harmed and only allows the whistleblower, as has been mentioned, to sue for limited compensation long after the event and long after the public interest matters have been buried. And I'll start to finish by saying this. The government, Mr. Speaker, continue to say that it's premature to conduct a review of whistleblowing legislation. Quite the opposite. I think it is well overdue. That this is what those who have been affected by the failures of legislation are telling us, and it surprises me that those of us on the opposition benches or the government benches think that that we know better than those people. The legislation in relation to whistleblowing is about prevention of disaster, Mr. Speaker. It's about prevention prevention of death or wrongdoing. It is therefore appropriate that legislation is equally serious in response, with appropriate pre-detriment protections for those who blow the whistle and appropriate sanctions for those who are determined to discount, punish and harm the voice of the whistleblower. I'll just end with one question, because this motion talks about protection of broader people and widening the scope of the legislation. So job applicants, volunteers, interns, non-executive directors, public appointments, priests and ministers of religion, foster carers, members of the armed forces, all of those people are not afforded protections for whistleblowing under the current regime. Has the government any plans to extend the definition of worker to include these categories? Many thanks.
Thank you. I call the Minister, Kelly Tolhurst.
Thank you, Mr. Speaker, and I would like to start by thanking the Right Honourable Member from Norfolk and my honourable friend from Stirling for securing this important debate today. I would also like to congratulate the Right Honourable Sir Norman Lamb on his knighthood in recognition of the commitment to public services. I also want to thank all members for their contribution today, and particularly in regards to their passion that they have expressed in putting the concerns and their arguments that they have around a UK whistleblowing policy. Now, government recognises how valuable it is that whistleblowers are prepared to shine a light on wrongdoing. This is important at an organisation level, but also more broadly for society, so that issues such as an abuse of power are brought to light. Today, this afternoon, stories have been shared in the House of people that have been disadvantaged and have experienced severe detriment. Effective whistleblowing policies enable workers to speak up to prevent wrongdoing and fraud that helps protect employers from financial loss, reputational damage and building their trust with customers. However, those who blow the whistle should be able to do so without fear of recriminations. Employment protection enables workers who have blown the whistle to seek redress if they are dismissed or suffer detriment at the hands of the employer because they have made what is called a protective disclosure about wrongdoing that they have witnessed at work. I can reassure my right honourable members and honourable members that over recent years the government has taken steps to support a cultural change in relation to whistleblowing in all sectors. A number of statutory and non-statutory improvements have been made. This includes guidance for whistleblowers on what they need to do to make a disclosure whilst preserving their employment protection, and guidance for employers, including a non-statutory code of practice. Now, I do highlight here that my honourable friend from Stirling and the honourable lady from Oxford East mentioned around particular guidance. I think the honourable lady from Oxford East, when she was talking around MPs and some of the clarity that we have of dealing with people that may come to us for advice, what I would like to say is I'd like to go away and see if there's any kind of guidance that possibly we can do to work up, particularly for MPs, so it enables us in our ability to deal with our constituents. I will give way.
Very grateful. She will have heard some of the comments I made about the Financial Conduct Authority and their quite tepid approach at best to whistleblowers. What are we to do when effectively an agency that's commissioned by the government does not follow through on its whistleblower obligations?
I thank my honourable friend. I was preparing to come to that, but what I will say to my honourable friend is that he's absolutely right. The FCA falls under the control of the HMT, Her Majesty's Treasury, and some of the concerns that have been raised here today. What I am prepared to do, and actually I'll go into further, but go into some more detail later on, but what I'm wanting to do is to meet with HMT and make sure that we raise some of the issues that have been raised here in the House around FCA, and me to raise those issues with them in relation to whistleblowing policy and some of the concerns. I'll give way to Honourable Gentleman.
I'm very grateful to the Minister, and I thank her for her very kind comments. I'm sure she's going to come to it, but would she agree to meet with us to discuss the case for a review? Because I think a review of the legislation, not just guidance, is absolutely necessary. And it was a Conservative who introduced the Private Members Bill, and it could be a Conservative government that modernises it and ensures full protection for all whistleblowers.
I thank the honourable gentleman for his right honourable gentleman for that, and I am happy to meet with members or colleagues to talk about things that particularly we would like to see done in this particular area. And I do note his differentiating between guidance and a review, but I will come on to that. But I do want to outline what the government has done and what steps are being taken, whilst I do understand that for some colleagues that hasn't gone far enough. We have increased the scope of those protections by whistleblowing laws by extending protection to NHS students, nurses and midwives. We have also introduced whistleblowing protection for job applicants in the health sector. We have also fulfilled the commitment to keep the prescribed persons list up to date. In response to the recommendations from the Women and Equalities Select Committee, we have committed to adding the Equalities and Human Rights Commission to the list of prescribed person at our next annual update, which will be subjected to parliamentary time, but we aim to present to this House before the end of the year. And as I outlined earlier, I will look to see whether there's things that we can do within that to make it clearer. We have also introduced guidance for prescribed persons and employers to help them support whistleblowers, and the most recent reform was a new legislative requirement for most prescribed persons to produce an annual report on whistleblowing disclosures made to them by workers. I'll give way.
Thank you for giving way, Minister. I think the point, I appreciate all the work's been done, but the point that I mentioned earlier on about a 3% success rate at tribunals, surely that tells the government that this legislation is not working. Minister.
Well, I would say that the whistleblowing legislation at the moment is regarded as proportionate, but what I would also say to the honourable gentleman, and I'm just about to come on to, is that as new evidence comes to light, as things change, it is right that we would always keep these kind of policies under review. And it is right that we have these debates in the House of Commons so that we as a government are challenged to what's happening now and how we can improve. So I would like to make some... OK, I'll give way.
It's just what has come out clearly from this is that PIDA only allows 3% of people to get some redress, and it's only some redress. Surely we require legislation that actually protects the whistleblower right at the start of the process, not trying to mop up afterwards.
Well, look, I thank the honourable lady for that, and I do understand that the passion and the concerns and the statistics, but I also recognise we need to implement a framework that works successfully across all sectors, and actually some of those challenges aren't easy. And when you look at particular sectors and some of the challenges that could be implemented. So it's absolutely right that we do what we can at pace, but we also look to we look to review and we look at things that are coming in future. But I do take her point. The relevant prescribed persons were required to publish the first of these reports by the end of September 2018, which we added to the parliamentary libraries. The second annual reports will be due by the end of this September, and they will be obviously available in the House libraries. But the reporting duty does increase confidence in the actions taken by the prescribed persons, because it is enabling greater transparency about how those disclosures are handled. With these improvements, we believe that the whistleblowing framework, as I've said, is proportionate, but I do accept that new evidence and practices come to light and we need to keep the legislation under review. You will also be aware that the EU have developed a whistleblowing directive that we are expecting to be approved this summer. The directive is very wide-ranging and comprehensive in its scope, and we will have to consider how we take it into account into UK law. And because under the current terms or the withdrawal agreement that's been discussed, we had it could fall within that implementation date, but obviously, as we know, that there are question marks on that. As you know, the government has been clear, and the honourable gentleman for Ellesmere Port and Neston raised it, but I want to reiterate again, we have been clear, and the government has been very clear throughout the whole of the EU process, that we will not be reducing workers' rights when we leave the EU. And absolutely, whistleblowing and how we move forward on that falls into the whole workers in employment protection space. So hopefully, honourable members will take that as some kind of commitment from me at least. In terms of a funeral review, it is right and proper that we review government's whistleblowing framework, but it would be premature at this point. But that does not mean to say that it is not going to happen. There's been many issues spoken of today. I do welcome the work on the ongoing work of the All Parliamentary Group for Whistleblowing, chaired by the Right Honourable Member and Honourable Member. And officials are hoping to meet with the APBG soon to particularly discuss the legislative framework and protection for workers, and to feed into the internal work. So I hope that the honourable gentleman were able to speed that process up. I just want to touch on as many of the points I can quickly, Mr. Speaker, if that's okay. Or not. Sorry. The Right Honourable Member, the Right Honourable Gentleman for North Norfolk talks about foster carers. This is an area that I'm particularly passionate about, and I understand the challenges that there are with foster carers, and we do need to protect those people that are doing an absolutely fabulous job looking after the young people that in our society that desperately need help. I must point out that it is a requirement for fostering services to have a complaints procedures and whistleblowing policy. In addition, foster parents whose approval is terminated or terms of approval amended have the right to challenge the decision by a review of the independent review mechanism. Now, I understand my Right Honourable friend's having a meeting with the DfE where he will review some of those challenges in more detail, and I will be very interested to hear the outcome of those particular meetings that he has. Also, in regards to non-disclosure agreements, the House will know that we published a consultation early on in the year. That is now closed. We're consulting on various elements of that. I know that there are certain opinions in the House in regards to that, but we will be obviously issuing a response very soon. But as I have said before at this dispatch box, it is unacceptable that NDAs will be used to cover up or try to cover up wrongdoing, and we have been clear that any NDA does not stop people's whistleblowing protections. Very quickly on that, in regards to health, which is obviously something that has had many honourable members very concerned from North Norfolk and Central Ayrshire. There was the creation in 2016 of the National Guardian Service. This is now a network of freedom to speak up guardians in the NHS Trust staff, and staff can speak up and get advice on raising concerns with their local guardians, including the National Helpline. Following the independent inquiry into Gosport, the government responded by announcing it will legislate in parliamentary time for NHS trusts in England to report annually on the level of staff that speak up, increasing the transparency. I can also say that the Department for Health and Social Care are still considering further protections on how they can strengthen protections for workers within the NHS. So that's something that we are moving forward with. In regards to the financial regulation, I've touched on that, and I'm very conscious of time, Mr. Speaker. I've touched on it briefly. The honourable member from Ferscombe Morton spoke of the work that he does in the role of his APPG, and I have many conversations with him across a number of things, and I understand that FCA investigation the FCA are currently conducting 2 investigations into HBOS, including the bank's communications with regulators following I've lost my word now. Following the issues of misconduct, and I'll be looking forward to looking at those reports. And as obviously I've always said at the dispatch box that I will be prepared to meet with Treasury Ministers to take this further. In regards to the member for Poplar and Lionhouse, the issue that he raises particularly about his constituents, Miss Davis, I'm happy to meet with HMT on this issue. I understand it's a live case, and I'm more than happy to speak to him outside of this debate. I understand all the concerns that have been raised by honourable members across the House on the FCA, and hopefully I've given you some assurances that I will take them forward. Blacklisting, again, the Information Commissioner is opening a call for evidence on the implications of modern employment practice in recruitment and selection. Hopefully this will bring some light onto further what could be done around blacklisting. The honourable member for Strangford, he knows that we are undertaking the reform of the FRC, and after the independent review that was done by Sir John Kingman. And then, Mr. Speaker, I would like to end by saying, hopefully, I've given some reassurances to the House in the time that I've had that I am taking this particular issue seriously. I know I can't stand here and promise them exactly what they want, but what I am prepared to promise is that while I'm in this post, I will do what I can to work with them and to try and address as many of their concerns as they need. And once again, I want to thank all those whistleblowers who may be watching this, who do feel that they've had detriment for what they have done, and also for the members of Parliament for making sure that their voices are heard in this chamber. Thank you, Mr. Speaker.
Thank you. I think the right honourable gentleman for North Norfolk wants a 1-minute wind-up. Indeed.
I'm very grateful, Mr. Speaker. This has been, I think, a remarkably well-informed debate, and I think what's striking about it is that there's been a complete unanimity of view presented to the Minister that actually the law at the moment is not adequate. It's not, in her words, proportionate, I'm afraid. We hope very much that we will convince her. I'm pleased that she's agreed to meet with us, but we need modern legislation that not only protects people who do the right thing, but actually because we all rely on them to ensure that we have the best business practices in this country, the best public services, the safest public services. And we only get those standards if people speak out. And at the moment, we don't give them the necessary protection in order to do so.
Thank you. The question is as on the order paper. As Minister, have that opinion say aye. Of the contrary, no. I think the ayes have it. The ayes.